People v. Licius.
Can I reserve 2 minutes for a rebuttal, please?
Yes.
Good afternoon. Simon Greenberg on behalf of Mr. Licius. The prosecution did not declare trial readiness at any point before the court's closure on the 90th day of the criminal action.
But why doesn't General Construction Law Section 19 apply, the midnight to midnight?
General Construction Law 19 and 20 do not apply here because the issue in this case is the meaning of the phrase ready for trial. It's both ready for trial and that it has to happen within 90 days. It's not merely a question of counting how many days have gone by.
I understand that point, but the reality is if they had filed it in person at 4:59, no one's holding a trial at seconds after that.
That's true, Your Honor. But the prosecution still needs to be, an off-calendar statement of readiness still needs to be filed at a time when the prosecution could have gone into court and said, we're ready to start a trial now. And there are still things that can happen at 4:59. There aren't that many things, but there are a few things.
What if they file it, I'll give you 9 a.m., but the judge is on vacation that day?
If they file the...
9 a.m., the last
Yes.
day, but the judge happens to be on vacation that day. Again, no one's going to trial.
Well, if the judge is on vacation that day, they could file an off-calendar statement of readiness in the clerk's office.
And what if the clerk doesn't review it for a while? It sits,
Well, that goes to the question of how does the EDDS rule apply? And the language of the EDDS rule is unambiguous that a document may not be considered filed until the moment when it's reviewed by a clerk.
So if people file it a week early, but the clerk's office is incredibly busy or something like that, and they don't get to it for 10 days, people are out of luck.
I think, Your Honor, that the EDDS was created to make it more convenient to deliver documents to the court. It wasn't created, it was created as a delivery system that was supposed to make it more convenient to deliver documents to a court.
But the rule is that whenever the clerk gets to it, that's only to confirm that everything has been filed appropriately. It is still treated as effective as of the time it was actually electronically submitted.
That's not correct, Your Honor, because the language of the rule is unambiguous that filing cannot be deemed to occur until the review by the court.
I think the judge's point is it's deemed to occur then, but it's effective as of the date you actually filed. And the risk you take is you haven't done the thing correctly, in which case it's deemed never to have been filed, right?
Well, the word deemed in this context, it means that the fact that the act of reviewing the document is what causes the document to be deemed filed. It's not a grant of power.
Under your system, I think as the chief judge was getting to, litigants just have no idea whether this filing is going to be timely because it will depend on the staffing and the vacation schedules of the office.
I think that the risk that could happen is built into the electronic document delivery system because it's a delivery system.
It seems like there's some tension between that and the proposition you advanced earlier is that what we care about is that people are actually ready for trial. So my hypothetical, they were actually ready for trial a week ahead of time, but because of backups in the clerk's office, or maybe the papers got stuck under a stack of something and nobody noticed them for a while, they were actually ready for trial, but because of a clerk's office screw-up, it's not actually filed until after the deadline, and that seems to be in tension with the basic proposition.
Well, Your Honor, the case law is clear that a document that the people aren't actually ready for trial until if the way that they stating ready for trial is an elemental prerequisite of being ready for trial, so that they can't actually be ready for trial until the document is filed.
But it seems like under your reading, it makes it really difficult to ascertain exactly when that happens because it is a function of when the clerk happens to review it. If you are spending a lot of time litigating in court, that seems like it would create a lot of heartburn.
I think that that's a risk that any party using the EDDS system takes.
So what is one supposed to do then? You file it, let's suppose you file it the morning of 9 a.m., I think someone said. Are you supposed to call and find out if it's been reviewed? And if it hasn't been reviewed, what are you supposed to do?
The system has a warning, and in fact, the warning is given repeatedly. So I think that, yes, you could call and see if...
What if you're told the clerk is on vacation today?
I think the EDDS system, it's a delivery system that was meant to make sending a document more convenient and not to be used when you're up against a deadline. And so...
So it seems like you're
yes.
suggesting that in fact, using the system is, at the litigant's peril.
It is at the litigant's peril, Your Honor, and that's something that they're repeatedly warned of on multiple pages when they actually start the process of delivering
What is
yes.
the last thing you filed in court where you're not up against a deadline?
I think people usually are. Yes, litigants are very often up against a deadline.
It seems like it renders the system effectively unusable, which would be a peculiar result.
The language is clear and the warning is clear.
But isn't e-filing created to help facilitate systems participation, making it more user-friendly? What you're suggesting is that perhaps we get away from e-filing. It's abolished.
Well, EDDS is different from NICEF. NICEF is a filing system, and the language of the rule in NICEF is clear that...
But if
yes.
it's going to have such harsh results,
Yes.
it disincentivizes anyone to do anything but in-person filing. And then wait there. I demand that you look at it right now, because that's what you say. It's not even effective until the clerk looks at it.
I think EDDS is, my understanding is that courts are moving toward trying to get all trial courts on the NICEF system. And the court also has the power to change the rule if it, because it's a court rule that was passed through the authority given to courts to pass the rule. So
What would be the change?
The change would be to change the rule to say that a document that is sent to the courts through EDDS you could graft language onto the current rule to say that it shall be deemed filed as of the moment when it was received. So that would make it clear that even though the review doesn't happen until after the document is received, that it could be deemed to have occurred
Could a court decision
earlier.
do the same thing?
I'm sorry?
Could a court decision say it's deemed filed when it's filed?
A court could not do that, Your Honor, because the legislature, the Constitution and the legislature both gave the courts power to pass rules and make them have the force of law. And here, EDDS specifically says that documents can't be sent to the court using the EDDS system except as explicitly provided in this rule. And so courts can't just go around rules that are clear and are binding on them. To get back to the question of whether the prosecution has to state ready before the court is closed, I think it's undisputed here that that's always how stating ready has functioned since the legislature enacted 3030 in 1972.
So what do the additional 7 hours matter?
I'm sorry?
4:59 to 11:59. I know why it matters in your case.
Yes.
That's sort of a systemic matter.
Well, I think, as I've said, there are things that can be done, up until the moment that the court closed. The court can tell parties, get your witnesses together.
Let me ask you
yes.
this, because you're relying on that rule, but, the GCL does say that it applies to all statutes, right, adopted afterwards. 3030 is adopted afterwards. So, of course, a statute trumps any rule. Why,
Yeah,
again,
yes.
circling back to where I started with you, why doesn't the GCL just resolve this issue for us?
The GCL doesn't resolve this issue, Your Honor, because the GCL has an exception. It says in Section 110, the GCL says this chapter applies only if, unless it's inconsistent with the context of the language construed or the object of the statute. And here, the object of 3030 is that the prosecution must have completed all of its prerequisites to being
And be ready for trial. That doesn't mean the trial is starting the minute they file it.
That's correct, Your Honor, but they have to be able, they have to have gotten the case to a point where they could go into court and say to a judge, we're ready to start a trial now.
I'm just trying to understand how the practical objective of 3030, which you're identifying,
Yes.
is implicated here. So I agree with you. I think you said to the chief that, yes, many lawyers file close to a deadline, right? Maybe that's human nature. So if I have a brief due or some other filing due on Friday, I mean, really, what would I do? Would I call the clerk's office and say, can you confirm the clerk will be there and available to review? And if I file on Friday, I am not sure that a flood of phone calls like that would be met with a lot of enthusiasm, might not be the best use of time. And so how does a lawyer actually operate under that scheme?
I think the answer, Your Honor, is that, as you asked me earlier, a lawyer does use this system at their peril. And they could, if they really needed to be absolutely sure that a document is going to be filed, they could go to the courthouse and file it.
How does that serve the objectives of 3030? That either abandoning the system altogether because of the risk or some flurry of phone calls to ensure that actually my filing will be reviewed if I get it in by the right hour?
I think one reason it serves 3030, Your Honor, is that I think that when 3030 was enacted, it's true that parties are often up against a deadline, but what was not expected is that prosecutors would be pushing getting ready to trial until the very last minute of the day.
So in a court that is on NICEF, right, I could file a statement of readiness off calendar at 10 o'clock at night?
If it is on NICEF?
If it is on NICEF.
You cannot, Your Honor, because of the court business hours still are the deadline for when the prosecution could stay ready for trial.
I thought you were making a distinction before between NICEF and EDDS.
I am making a distinction because there's two issues here, or you can think of the case as involving two issues. One is, what is the last time that the prosecution, can I finish my answer, Your Honor?
Yes, please.
The last time that the prosecution can state ready for trial is when the court is closed. But in order to do that off calendar, they have to file it. But if they're using a system that has a specific definition of filing, the filing may not happen until the next day, even though they. There's two different questions here. One is the meaning of filing, and one is when do they actually have to declare readiness.
Yeah, but it sounds like you're saying that whether you file by EDDS or whether you file on NICEF, you can't file after 5 o'clock.
You can't file after 5 o'clock or what the regular business hours of that court
yeah,
are.
so in some ways, your argument the EDS rule doesn't really matter to your argument. You can't file, once the court is closed, nobody can file.
Well, the EDDS matters for our argument. Well, it doesn't matter in this particular case, Your Honor, because the prosecution did submit the document after the court was closed. But in a case where they submitted it before the court was closed, when they could have stated ready, they are still taking the risk that the requirement of filing, which is a requirement of being ready for trial, might not actually happen until the next day. Okay. And so there are two issues, and
I'm sorry, because the clerk will not review it and confirm that it's been properly submitted and filled out and the fees paid. Is that what you mean?
Yes, Your Honor. Even if the prosecution could state ready for trial, if the document is not actually reviewed until the next day, they're still out of time.
Well, you have a point there. I mean, you have. I'll give you this. You do have a point about the peril, even for someone who goes in person with only 2 minutes to remain. First of all, they might tell you leave, that's unlikely, but they take it and in those 2 minutes they say, there's something missing, we won't accept it.
Yes.
You probably don't have 2 minutes to correct it, I mean, depending on what it is, but if it's something that takes more than 2 minutes, you're out. So you're right. In that sense,
I think that's right, Your Honor. I think that if you come to court and, I mean, the prosecution statement of readiness is a
but
fairly
at least
simple
you know
thing.
in the moment, right? I mean, yes, you're taking that risk, you know in the moment, maybe I can correct whatever the problem is in the moment, but with the filing that the clerk is going to look at it the next day, that's a much higher risk.
It is a higher risk,
Which
but then-
means, again, you've disincentivized.
But prosecutors are, and any party, in any case, is repeatedly warned that the system might cause their filing to be delayed. So the warning is given for a reason, and it specifically tracks the explicit language of the rule.
Well, they're warned that it might not be accepted if they don't comply, right?
We read the warning, and I think the unambiguous language of both the rule and the warning is that the filing cannot occur until the moment that the document is reviewed. But I'll save the rest of my argument for rebuttal. Thank you.
Thank you.
Good afternoon. Julian Joris for the People respondent. The People communicated the readiness to the court before the end of the 90th calendar day. That statement of readiness was timely. The availability of court facilities to hold or begin a trial is immaterial to the People's readiness. It is all about whether the people...
But when 3030 was enacted, courts were not open past 5. It was regular business days, right? They could only go in while the clerk's office was open. Why aren't we then limited to having to recognize that 3030 was passed with the intention that you're submitting papers until while the court is open, and that's it?
Well, first of all, I'm not sure that the premise of the question is accurate. Even now, hours among courts throughout the state vary widely. You might have some local criminal courts with a part-time justice who sits a couple days a month with limited hours. And those hours, of course, might not be the same hours that the clerk's office is open to accept filings, whereas...
True, but the legislature could have understood that there will be courts that do close at 5, let's just say with 5, that's generally the case. And that's it, you can't go later than that.
I will say that's generally the case for most purposes. I would guess in many courts, Your Honor, but of course, we have, in New York City, we have 7 days a week. The arraignment parts are up 16 hours a day, going to 1 or 2 a.m. So again, I don't think that we can make any generalization about when courts are open, when they might be accepting filings, when they might be able to hold proceedings, whether those two things are going to be coextensive or not. So all of which is to say, if the legislature had meant to say 5 p.m. or close of business or something like that, the legislature would have said that. The legislature knows how to say that. It says that in other statutes when that's what it means. It said 90 days. It meant 90 days. And here
Counsel, I'm sorry.
Yes.
Here. There's one part of your argument, maybe I have it wrong, that I was struggling with a bit. You say that if you do choose to use this system to do this, you
Right.
don't have to follow the rules. Is that part of your argument, or did I misunderstand?
Not quite, Your Honor. I think there's two distinct arguments going on here. One is about what does 3030, what does the statute 3030 mean,
Okay.
right? Which is ultimately this court, and on the way, the lower appellate courts, construing what does it mean to be ready for trial, which is the phrase used in 3030. The other argument is about what do the EDDS rules mean.
Right.
And my point is for purposes of statutory interpretation, whether it's people are ready for trial or what it means to file something for purposes of a certain statute, this court controls and this court decides, right? Obviously, the practices and policies of the lower courts can, as a practical matter, affect how and when and where you
Let me
can
ask you a
file.
hypothetical, maybe to clear it up a little bit. So I think I talked about this a little bit before. You file in the system,
Yes.
you file it on the right day, late at night, whatever. Clerk reviews it the next day and says, you know what, there's a defect in this filing. It's not effective. Have you filed and declared readiness or not, in my hypothetical?
I would say that that would probably depend on the nature of the defect, just as a matter of general experience. I know often if there's a sort of ministerial defect, such as, oh, you got the docket number off by 1 digit, that kind of thing, generally you'll get a call from clerk's office going,
But is that
Cure
because
this.
it's a 30/30 filing, or is it just because that's the way the system works?
just in general, that's the way the system works, right? If there were a really substantive, if you said, oh, I'm filing my statement of readiness, and it was just turned out to be a blank piece of paper, that would probably be not good, And I'm sorry to speak in sort of
No, but you would then
generalizations.
accept that you would be bound by the procedural rules of the filing system.
Right, well, that's what I think the EDS system says.
Except if I'm understanding you, you're saying if the defect is non-substantive, purely ministerial, got the wrong number, or 1 digit off of the number, that would not render the submission late.
That would be my position. Obviously, this has not come up in this case, but my overall point.
That's not even what the rule says.
Well, and this is why it's a little hard to respond to these hypotheticals, other than in very general terms. That I do think it would depend on the nature of the defect, and some would be more substantive, some would be less substantive.
Let's say someone goes in at 4:59, hands it to the clerk notices a defect that cannot be corrected in that moment, but if they went back to the office, they could correct it and bring it right back, but they're not going to get back by 5 in this hypothetical. Did
Again,
they
in
fail to file on time? Because the clerk refuses to accept the filing until that ministerial, we'll stay with ministerial for the moment, defect is corrected?
I would say, as a general matter, if the clerk says, I will not accept this, go back and come back when you fixed it, that means that you weren't able to file it on time. Whereas if the clerk says, I'll take this for now, but you have to fix this within, 5 days or 3 days or something, then that would constitute the clerk accepting it.
That's a lot of power for a clerk.
Well, they do have a certain role in reviewing the documents and making sure that they are
Yeah.
correctly
How
filed.
much time do they have to give you to correct it?
Again, speaking in generalities,
They'll stamp it filed,
right.
and let's say you never correct it. What's going to happen to that document?
Then you've never filed, if you've never corrected it,
Well, what does the clerk do with it? They put it on the side and give you a couple of days, you don't show up, and what do? Mail it back to you?
I mean, in my experience,
Yes.
they say, I actually had this somewhat embarrassingly happen with an appellate division brief. Clerk's office had sent an email to a person who was no longer with our office saying, you got the docket number wrong, please fix this. A few days later, they sent another email, which finally made its way to me, saying, you got the docket number wrong, please fix this. And we did. At a certain point, I believe they say, we gave you a few warnings, we're rejecting it. And again, we're necessarily, because this isn't the fact of this case, necessarily speaking in sort of generalities. So it's the kind of thing that can happen. And I can't speak to every possible
They
eventuality.
do that for everybody? Pro se complainant in a civil case comes in, says, well, I'll take it, but you got to fix this in a couple of days.
Your Honor,
You don't know, it's okay.
I've never, I'm sorry to say, or maybe not sorry to say, I've never been a party to a civil case. So I really couldn't speak even
Fair
from
enough.
general experience there. I like to think the clerks at the appellate division are very nice and understanding people, so I don't see why they wouldn't do that. And in general, I think courts tend to be more forgiving of your pro se litigant than they are of people like us who are supposed to know what we're doing.
Except you got those 2 notices.
Well, nobody's perfect. So I do think here, just getting back to the overall 3030 issue, I think under Kensia and Stiles, it's incredibly cut and dry. Frankly, even if it weren't, the general construction law definition of a day, even if we didn't have Stiles saying we're applying the general construction law to 3030 time limits, the general construction law definition of a day as a calendar day, midnight to midnight, that's the common meaning of a day. A day is a day is a day. So if the legislature meant to say something else, it would have. I think under Stiles, again, it's really that simple. We have not only here's what the words mean, but here's what the court has already said the words mean. I think to the extent, well, I'll keep on addressing the EDDS rules issue. The defendant's interpretation would make EDDS, frankly, worse than useless, because it would mean, well, it would apply to any party using that system in any case, including whether it's pro se civil litigants up against a statute of limitations, whether it's the people filing 3030, statement of readiness, whether it's the defense. I think it's a 5-day time limit under 19050 if you're going to move to dismiss an indictment under that provision. Almost every litigant, almost all the time, is in fact operating under a deadline. So if EDDS is really just, send it into the void and cross your fingers and hope that something happens, that would mean that, well, at least the lawyers would know this system isn't worth using, and it would just become a trap for unaware, unknowing pro se litigants.
Do you know if your office has filed statements of readiness on NICEF after 5?
So NICEF is just in the process. I believe the NICEF criminal,
Yep.
Rolling out NICEF to criminal courts is just in the process of happening in Kings County. So I think under NICEF, obviously we wouldn't have, even under the defendant's reading, we wouldn't have this issue with the filing system rules. I believe that that would be entirely appropriate under 3030, and I believe that there would be no dispute as to the filing time as under the NICEF rules, but we haven't yet started using that case. They're just kind of spinning that wheel
Yep.
up. I think, frankly, to the defendant's point that in passing 3030, the legislature couldn't have possibly contemplated that the people might announce ready on the last day. They gave us 90 days. We don't want to use all 90. I mean, the incentives are 3030 are such that if you can announce ready on day 89, you won't wait until day 90. If you can announce ready on day 88, you won't wait until day 89. You don't want to announce ready and then have 0 days left of wiggle room. Some cases, unfortunately, we do have to use all 90 days, as in this one. Some cases we don't. The number of cases that have a fairly late in the game statement of readiness obviously has increased since the passage of 245, since we're, trial assistants are obviously not only having to make sure they have essentially a triable case and a triable accusatory instrument, but to gather all the voluminous discovery. So, and obviously you can see in this case, the information was filed on June 22nd. That wasn't what was delaying it. It was the issue of gathering discovery. So I think in terms of statutory interpretation, again, 90 days means 90 days. And I do think that is it's about as straightforward as it can get. The fact that now the court has rolled out electronic filing systems. The court can do that, right? Just as the court could have said, well, now our clerk's office is going to be open until 6, or now our clerk's office is going to close at 4:30. The court could have said, well, you know what, now we have an after-hours drop box, so you can just leave things hard copy. Technology that was perfectly available in the 1970s when 3030 was written, in 1985 when Kenzia was decided. There would have been no problem with the court doing that either. So I think nothing here about the fact that it was via EDDS, nothing here about the fact that it was electronic filing, really turns this into some sort of novel situation that shouldn't be allowed for under 3030. If there are no further questions?
Thank you.
Thank you.
Thank you very much. To Judge Rivera, to your question about what happens if a clerk says, not everything's here, fix it and come back. You know, in our opening brief, we did cite federal rules which say that if there's a defect in a filing, a clerk has the power to say, fix it and come back, and it'll be deemed filed at the time when you first attempted to file it. No such language appears in the EDDS rule. The only language that appears in the rule is that the document shall not be deemed filed until it's reviewed by a clerk. And again, just to go back to the warnings make clear that a party is using this system at their peril. It may not be the best system, but the language is clear and the warnings make it clear.
What does deemed mean in that sentence?
Well,
Why
I
isn't-
think-
what if-
yes,
isn't
Your
your
Honor.
reading, it isn't filed until?
Deemed
What's
in
deemed
that
mean?
context, Your Honor, I'm sorry for interrupting.
No, please.
Means that once the clerk reviews it, that is the act that causes the document to be deemed filed. It's not a grant
Why
of
isn't it just
authority.
filed? It won't be filed until, that would be then. It won't be filed until the clerk approves, and then you know, hey, when the clerk approves, it's filed, but it's deemed filed, seems to me to indicate deemed as the time you actually brought it.
Well, to your point, Your Honor, we cited a number of rules and statutes in our brief that showed that when a court or a legislature wants to say that something can be deemed to occur before something else, it will be explicit in saying there are rules that say a document that is submitted at X time and then determined to have defects that are later fixed will be deemed to have actually been filed earlier as long as the defects are fixed.
As several people have been asking you, and as he's argued, of course, your interpretation would render this system practically useless.
It's not useless, Your Honor, because it still provides a more convenient way for parties to send documents to courts, perhaps not near a deadline where time is really of the essence, but at other times during the litigation, it still could be more convenient. And the last point I wanted to make was that my adversary talks about courts that have irregular hours, that aren't open at all times of the day, that aren't open all days of the week. That was a problem that always existed. Prosecutors were still able to comply with their obligation to be ready for trial. And the fact that there is now a way to send documents electronically didn't somehow create a problem that didn't previously exist.
Thank you.
Thank you, Your Honor.